话呢，他在纽约州的话 ，New Jersey 的话呢，执业了11年，2年前才来到休斯顿，在美国的一个 Top 9、Top 10的一个律师事务所，实际上是等级，做诉讼合伙人，最近so Brian yours joined us over a year，已经超过1年，在我们所现在是我们所这个商业诉讼的一个非常重要的一个 partner。
Good afternoon, everyone. Thank you for coming. I have no idea what he said except for some of the words, but it sounded like he wasn't talking a lot of stuff about me this time. So, thank you for coming today. One question I have is, I kind of want to get a sense from you guys. How much experience do you guys have with the U.S. court system or litigation in general? You want to kind of tell us? A little bit?
Yeah.
Does anybody, let's put it this way, does anybody have a lot of experience? Do they feel like they kind of know how the American legal system works pretty well? The differences between, how the U.S. system versus Chinese system works? Does anybody feel really confident on that?
Well, I learned from the movies.
Okay. So that's why I think it's important to start here before we get into the weeds on the law. The law in the United States and the law in China are vastly different, but most importantly, there's fundamental differences in the court systems. In China, the courts are an extension of the government. In the United States, they're independent, or at least they're supposed to be. And there was a famous case in 1803 called Marbury versus Madison. And to save you all the boring details, what boiled down to is that the president wanted to appoint midnight judges and missed the deadline and said, well, I'm the president, I don't need to, I can do whatever I want. And Congress didn't oppose. So there was a lawsuit. And so the court systems in the United States possess neither the power of the purse nor the sword. So when the Supreme Court said what you were doing was unconstitutional, that was the biggest test, or called a constitutional crisis in the United States. The question was the executive, who has the power of the sword, and Congress, who has the power of the purse, going to recognize and adhere to and follow the Constitution, which mandated a separation of powers where the court system was truly indeed independent. And as I think you all might have guessed, they did. They obeyed the Supreme Court's ruling and followed it. And that is a major fundamental difference. In China, if the courts go against the government, something probably bad happens to that judge. I'm betting. Here in the United States, now the downside to it in the United States, interestingly enough, is what do you think happens to a judge who ignores the law? Anybody? Anybody have a guess? What happens? What do you think happens to that judge? Think they go to jail? Do you think they get fired? Anybody?
It's lifetime, right? Once they become a judge, they're judge.
Well, in federal court, other than magistrates, they're lifetime appointees. And under the Constitution, officers can get thrown out for high crimes and misdemeanors, which takes an act of Congress, which is very expensive, time-consuming. Now, on the state court level, they're elected. And again, there's provisions in each state's constitution to eliminate corrupt officials. However, at the end of the day, the truth is nothing happens to them other than you get to go to another court, depending on. And so the system is geared towards checks and balances, and that's very important. So what you need to understand is that as much as you want to predict as much as you want to say this is a scientific equation, I have a contract, they breached it, where's my money? It's not that simple. Because a judge, for whatever reason, corrupt or otherwise, can say, nah, I don't agree with you. In New York, I once had a judge, there was a case where in New York, if a plaintiff moves out of state, the defendant can file what's known as a motion for security of costs. It's statutory. It means all you have to do is prove that they're out of state, and they have to just, the question is how much security. Well, the judge said, you don't have to bother arguing, I'm going to deny it. And I go, what do you mean? You can't deny it. The legislature says you have to. I said, there's the affidavit from the plaintiff saying they moved out of state. It's in their pleading. He says, well, I don't like it. It should be changed. So I said, okay. You didn't get in trouble, but what I had to do is I had to go to the next level, to the Court of Appeals, the Appellate Division, New York, and appeal. And in fact, they didn't even hear oral argument. They waited till the end, and they said, hey, Brian, and the other guy, come down here. The judge didn't follow the law, right? We all agree on that? Okay. All right, we're done. So that's the extent of it. So it's important when you are playing the litigation game to play the long game. I almost, especially in Texas, in New York it's a lot more expensive to appeal. Texas it costs much cheaper. So when you're litigating, especially in the state court level here in Texas, you're really playing the game for the Court of Appeals because ultimately they're the real trial judges. And so it makes things a bit longer and more expensive, but at the end of the day, it gives you a little bit more security that the right thing is going to happen. Because typically in litigation, most of the time, judges and juries do get it right, but not always. So one of the things I want to make crystal clear here, and I lectured about this in China when I went over there earlier this year, is it's amazing to see the differences of how Chinese businessmen and women do business and U.S. businessmen and women do business, because there is a major disconnect. And part of it revolves around the fundamental difference in the legal system. So for example, if you commit fraud in China and someone accuses you of it, what happens? Anybody know? Something bad, right? You go to jail, something like that. The U.S., not much. So what you need to understand is in China, you have a bit more security with your business dealings. And because of whether the type of government, what have you. The bottom line is, in the United States, it's the polar opposite. If you do business in the United States, you must always assume the other side on the deal, or the person you're dealing with, is going to screw you over, and they're going to defraud you. And if you don't, and if you do that, you will never, I promise you this, you will never, ever, ever, and I mean ever, be disappointed. Doing business type litigation, there is so much fraud, it's ridiculous in this country. It's ridiculous. And so that's why, unlike in China maybe, in the US, you have to, if you want to survive as a business person, you have to partner up with competent counsel. And I'm not saying you got to hire an in-house counsel or what have you, but you need to seek advice on counsel. I can't tell you how many times I've seen corporate governing documents screw over good potential businesses and allow one bad seed in that company to destroy everything. And all they had to do was pick up the phone, call someone like me, say, listen, hey, here's the document. Do you think this will suffice? We don't charge people for asking us questions. Lawyers aren't, that's not our ethical duty to do so. We only charge for doing things. And then I would tell you, well, I would do this, I wouldn't do that. If you want me to look at it and draft something for you, I'm happy to do it, and then I give you a price, whatever. But think about it. Even if I told you on the phone it's going to cost you $2,000, $3,000, do you know how much money I've saved you by doing that and legislating and bulletproofing your documents? I've saved you hundreds of thousands of dollars. We have cases right now where if an attorney had been involved early on, they wouldn't have to litigate and spend hundreds of thousands, maybe even $1 million in corporate disputes and stuff like that. Now, I know that's a bit tangential to labor and employment stuff, but there's a link here. And what I'm trying to tell you is, if you do business in the United States, you need to have counsel to guide you. It is just a necessity. It is the cost of doing business here. And I'm not just saying that because I'm a lawyer. It's a fact. Think about it. Everything you do in business has an intersection with the law. And unlike China, where it's more black and white, and it tries to at least curb abuse and bad behavior, the U.S., it promotes it, actually. Really think about it, it kind of promotes it. That's a whole other discussion, but I want you to understand that. So, this is just like, we've already talked about the comparison between the two systems, so I'm not going to get into it. The American court system, at its simplicity, right? There's a state, federal system. Supreme Court is the highest court in the land, and it's court of last resort for the country, but it's also the court of last resort for the system. The intermediary courts are the U.S. Court of Appeals, and the trial courts are called U.S. District Courts. Now, there are other specialty courts. We're not going to get into that, okay? And similar on the state courts, okay? However, when a matter is decided at the state court, if it involves a certain type of federal question or such a significant matter that affects the entire country, then the Supreme Court can review it, but it doesn't go backward.
So that's legal instead of.
Oh, okay. Oh, there you go. In the American justice system, the system's kind of divided into two things: criminal and civil. And criminal, I think, is kind of self-explanatory, and then civil is basically everything else, okay? And there are litigants, there are lawyers, and if you go through the whole gamut of litigation in court, at the end of the day, you will have either a judge or a jury decide your fate. Now, one thing I tell clients from the get-go is litigation is the most expensive and inefficient way of resolving the problem. And the other problem with it is that it takes control out of your hands. You're allowing, and the other side is too, is allowing a judge or other people or a jury, 6 or 12 people, to decide your fate in regards to that dispute. So the best thing you can do, if you can, and I encourage clients to do that all the time, is to try and resolve things outside of litigation or legislate it as much as you can inside your company, especially with things like employment law. There's a lot of things that you can do to curb or discourage litigation. So here's just some examples. So in litigation, you either go to federal court or state court. There are certain matters that can go into both, and there are certain matters that can only go into either or. If there is no diversity in a case and the case does not involve a federal question, it can never go to state court. Okay? I'm sorry, it can't go to federal court. It can only go to state court. And state courts are courts called original jurisdiction. I'm not going to get into all legalese. This isn't a law review, a law class. But here's just some examples of the type of cases that would fall under the ambit of federal courts and that would fall under state courts. The American legal system. So, in addition to their government not being part of the judiciary, one of the other most important differences between China and the U.S. is the jury system. Now, whether or not this is, I don't want to get into a political argument here, but Thomas Jefferson, the reason why I put this principle here by Thomas Jefferson is that the more people you have involved in the process, and the more that you have a hand in selecting those people, the more likely you're going to get a fair shake. And in my experience as a litigator, juries tend to get it right 95% of the time, where judges maybe get it right 80%. I trust juries much more than I do judges, although it depends on the judge, right? Judges are more political. So we kind of touched upon jurisdiction. So a couple of litigation points. So let's say you find yourself mired in a litigation. So what do? First thing I'm going to tell you is, if something happens, assume that it's going to be the subject of litigation. Don't sit on it. Don't hope it goes away. Don't be like an ostrich and bury your head in the sand. That's going to make it worse. You need to be proactive. And so how do you do that? Well, the first thing you do is, any documents you think that are important to that issue, you need to preserve them, retain them, and put them in a safe place. The second thing you must do is you must conduct an investigation. In the context of employment law, that is essential. You must do that. And the reason why you must do that is because you must show that you've done everything that you can to fix the situation, because there might be defenses available. For example, if somebody uses a racial slur at work and they're a supervisor or someone else, just because they did that doesn't mean that there's a basis for a lawsuit. I will tell you that it's not. It's not a nice thing to do, but unless there's an action that's discriminatory attached to it, it's not discrimination, and it's certainly not harassment, because harassment must be more than one time, unless it's so ridiculous, you would recognize it if you heard it, right? Someone being really graphic, just ridiculous, off the cusp type of thing. So the fact is that there are things called stray remarks, and we'll get into that further. But a stray remark in itself, especially when it's not connected to a discriminatory action, will get dismissed. It is not a basis for a lawsuit. The next thing is, talk to a lawyer. Doesn't hurt. No one's going to just start charging it out. And you can ask them, listen, I just want to ask a few questions. Do you think that, most lawyers will, of course, tell you, yeah, I think you need a lawyer. But actually, if you're ethical, which I hope people consider me, myself, and my firm and fan to be, will tell you the truth. No, you don't need to worry about that for now, right? It's just a stray remark. But what you have to do is, you have to bring the guy in, have an HR meeting, meet with them, make sure that the guy issues an apology, and you tell him never to do it again. Or you can fire the person who made the racist remark, right? Because if it's an at-will situation. And moving right along, you need to kind of, after consulting with a lawyer, you'll have a better understanding of what evidence is needed to either prosecute or defend a potential legal action. This is crucial because A, you want to preserve it, and B, if you get the evidence, you save yourself a lot of time and money, especially on the legal end. So when someone like myself asks, well, what evidence do we have to support it? You go, here you go. Boom. And it makes the case go much, much faster. And I don't have to charge for having to pester you about it or look it over. You've done most of the homework for me, and I just double check and make sure that it supports. The next thing is to see if there's a way to resolve it, right? Outside of litigation. Now, for example, you may not want to fire the guy who said the racial thing. Maybe he was just having a bad day. So maybe what you do is you try and mediate the dispute between the two people. Maybe the person who said the racial epithet to egg them on or said something bad about his wife or his mother, right? So you want to diffuse the situation. You want to consider alternative methods before going to litigation. Now, one thing that's very important in the employment law context is what you don't want to do, the best thing that you can do is actually stay out of court. So the Supreme Court of the United States held a year and a half ago that you are allowed to make as a condition of employment all employees sign arbitration, agreement to arbitrate, and a class action waiver. We'll get into why a class action waiver is very helpful, especially in the Fair Labor Standards Act and about wage problems. But the arbitration thing is very helpful because it becomes private. And it's a lot more efficient, it's a lot more informal, and also I also recommend people require a mandatory mediation, because mediation is the first step to try and resolve it. Try and resolve it early on. You know, there's no harm in that.
So, Brian, so are you saying that you strongly recommend every employer to have a binding arbitration in their employee handbook, or in addition to that, try to have a separate?
No, you mentioned it in the handbook, but if you'll see in your attachment, I've given everybody a copy of an example of what you need to do. And you should do this with employees, and you should do it with independent contractors, and you should have them sign it, and if they don't sign it, you fire them. Because you can fire them for that.
I really think that we have to stress this because this can save you millions of dollars in the future, can deter or prevent more than 95% of litigation or lawsuits because of this.
Yes, and I'll give you a very quick example. So under the Fair Labor Standards Act, let's say you're a big store like Charlie & Charlie or Macy's or something. And for years you've been treating your assistant managers as exempt. However, someone does some research and assistant managers kind of disgruntled and says, whoa, they should be paying us overtime. And so they start talking to all the other assistant managers. Now you have 100 assistant managers saying, where's our money? I've been working 70-hour weeks and I've been getting this measly salary, and I'm really not non-exempt. I should be getting overtime. What will happen is you will get a collective action where you have 100 people lining up under one umbrella, and it's going to cost you a lot of money. And it's going to save them a lot of money because they can just hire one lawyer to represent them all. However, if you have them execute the class action waiver and arbitration clause, A, they've contracted away their right to have a collective or class action. So now it's got to be one by one. Makes it harder for them. Second, it's in arbitration. Arbitrators consist of people like myself. And most arbitrators are fair but they're more pro-business. They tend to be more pro-business because they understand what's unsaid. Is that if you were to hit Macy's with this collective action and you were to have them pay whatever amount they owe, and it was willful, and they knowingly do it right, all that kind of stuff, you might put that business under. And then that's going to harm 20,000 people who are going to have no jobs versus 100. So these are things that educated arbitrators will take into consideration, even though you may not bring it up, but that a jury will certainly not, because you can't say that. That will be, they won't allow you to say that, because it'll be a subject of what's known as a motion. You know, we're going to give you a copy of all this, so I don't want to waste time and stuff. But I want you to do this, and you're going to laugh. But I want everybody for the next 2 weeks to watch My Cousin Vinny, the movie. I'm telling you, it's funny, first of all, and second of all, it really does give you an example of what it's like, the system. It really does.
I love that video.
Yeah. And his Vinny's opening statement is something I wish I could use on my last trial on the defense side. I mean, every lawyer has felt that way and says, there's nothing I can say. Everything he says is, is untrue. So I hope you guys take an opportunity to watch that movie. So, pre-litigation suit preparations, quick points. Investigate and preserve all the information and data first. You have to do the preservation anyway. That's called a litigation hold. Because if you don't and you lose it, you could be negligent, and there's something called a spoliation motion, which means that there will be sanctions against you for either being negligent or willful, and they can strike your pleading. So if you got sued, and they're like, well, where's all the evidence that of their complaints? Oh, I don't know. They might say, well, you know what? You burned it, you threw it away because you knew it was going to hurt you. And so we're going to make an adverse inference against you, have an instruction to the jury, oh, and we might just strike your answer, and now have a trial on damages. So you cannot take any chances. You will be completely behind the 8 ball. Hiding stuff is not going to save you because you're rolling the dice. Okay? Because although judges, clearly in a willful scenario, judges will do such extreme things. They'll give you the death penalty, strike your pleadings. But if you're negligent, they're more likely to just give you adverse inference. But it doesn't help. Because if you're a juror, what are you going to be thinking? Assume that everything in this file was really bad for them. That's the instruction, right? So you don't want that. So you do a corporate investigation, and so what you want to do is get an attorney involved if you can, or if you don't, you have to understand that some things are going to not be privileged then. So when you do a corporate internal investigation, you need to take these measures. And I'll just kind of let you read them, because like I said, I think we're pressed for time, so I want to kind of move this along. Witness interviews, one of the most crucial things you can do in the context of human resources. You must talk to people. Now the question is, do you want them to kind of be overt? Do you want to kind of announce, hey, something happened, we're going to be doing interviews? The problem with that is they might have time to prepare, change their story, versus just doing it unannounced. Now the problem when you do it unannounced, though, is that people start to become paranoid, and there are rumors coming around, and there's uncertainty. So you have to do a balance. You have to see what's the most important and effective thing. Typically, in my opinion, most of them should not be announced. You kind of want to keep it hush-hush, and you want to catch these people off guard, because if they did something wrong, they don't have time to prepare. They don't have time to ask for a lawyer, and if they ask for a lawyer, you don't have to let them have one. Remember, this isn't the government. You don't have a right to counsel. This is a company matter. This is a company investigation. You could say, sure, at some point your counsel could be at something, but if you're not going to give a statement, that means that you're being disobedient and you're refusing to cooperate. And that alone, you can fire them. And I've litigated these cases. And I've litigated these cases for some of the cities here in Texas. Gather, just more of the same, gather information. Also, determine if you need consulting experts. So, for example, if there's financial issues, if you think that there's a financial related matter, you think that there's stealing, pilfering, whatever, embezzlement, it's best to get a forensic account early on, so that while there's evidence there, while everything's fresh in their mind, so that before you go into litigation, you already have the hammer you need. Or maybe you need to find out whether or not the other side has you might be in trouble. Maybe you did something you didn't realize was wrong. You need to know that in advance, because you should probably settle that case or resolve it, right? Finalize your investigation, document it, and then take action. Decide what action needs to be taken and do it. Don't just let it simmer on the pot. You've got to be active in